I have to apologize. My office is a bit of an open concept, so you may hear a couple
Oh,
of
well,
people in the background.
that's par for the course nowadays, right?
Right? Yes.
Yeah. Yeah. Lots of people have kids and pets, and it's not unusual. So
Yeah,
we
absolutely.
just try to make it work.
We do what we can. Exactly.
Yeah. So we're up to 20 participants so far. So maybe we can start.
Okay, perfect. All right. Good afternoon, everyone. Thank you so much for taking time out of your day to come learn about best legal practices in owning and operating rental property. Today, we're going to discuss responsibilities of landlords and tenants. My name is Bita Di Lisi. If you already haven't done so, head over to our social media, like us, follow us on Instagram and Facebook. If you have one of these smartphones, you can scan the QR code located at the bottom left of your screen and add us in as an automatic contact to your contact list. For those of you who have any questions regarding matters that you want me to help you provide clarity, email is, of course, the quickest and best way to get a hold of me. If you call into the office, returning calls might take a little while. However, you're free to speak to anyone here. So let's get started. Next slide.
Okay.
We're having some technical issues with our new computers, so we're going to have assistants moving the slides, pushing the slides. So I won't bore you about background about myself. I'm here regularly every month, so many of you know me already. For the purpose of this presentation, everything we discuss is for information only, not to be taken as legal advice. If I can ask that you hold all questions to the very end, then we can hold a Q&A. Next slide. So in this presentation, we're going to talk about the responsibilities of landlords and tenants. Who is responsible for what? Some of the things may be an eye-opener. Some of the things you already know. But just a couple of preliminary things. The Residential Tenancies Act, or the RTA, this is the governing legislation that governs the realm of landlord and tenants. This particular piece of legislation came into effect in January of 2007. The Residential Tenancies Act creates a rental housing system that protects tenants, helps landlords, and promotes investment in the province of Ontario. The RTA, this piece of legislation alone, affects about 1.4 million renters in Ontario. And I'm pretty sure you know that there's a lot more renters than there are homeowners. So next slide. Let's talk about the LTB, the Landlord and Tenant Board. For those of you who've never had to attend a hearing at the LTB, consider yourself lucky. For those of you who have attended the recent LTB hearings, they're quite the experience. If you ever want to attend a hearing, just shoot me an email and I'd be more than happy to send you a Zoom link to a hearing. The LTB resolves disputes between landlords and tenants, and either party can apply to the board. The board is similar to a court-like setting, and disputes can be worked out through either mediation or adjudication in front of an adjudicator. I always recommend mediation, and I'll tell you why. Because at mediation, you have an influence on the outcome of the matter. At mediation, which is done on the same day as your hearing, an LTB mediator helps the landlord and tenant reach an agreement that they are both satisfied with. The outcome of mediation, again, as I mentioned, you have an influence on, or you have some sort of control over. Just remember, I always tell my clients this: you're not going to get 100% of what you want or what you're asking for in mediation. Now, of course, not everything in mediation can be worked out. If you can't work something out in mediation, you have no choice but to attend the hearing and let your matter be heard in front of an adjudicator. At the adjudication, that happens in front of the adjudicator. And what happens in front of the adjudicator, keep in mind that even though you're told to be at a hearing at a certain time, it doesn't mean your matter will be called at that time. The time that you requested to be at the hearing is a hearing block. And what that means is that your hearing, your file number, will accompany or be in addition to, I don't know, anywhere from 100 or 110 other matters that are scheduled to be heard that day. And if you're lucky for your matter to be heard that day, and if it doesn't work out in mediation, a landlord and tenant board member will decide the matter after hearing the merits of the case. So hearing the facts, listening to the evidence. Now, just remember I said that there's about 100 or 110 matters scheduled. So you're not going to have a half an hour just allocated for your hearing. In front of the adjudicator, if your matter goes in front of the adjudicator, the member will listen to your matter and the opposing side, and then they will apply the law. And then usually an order is final, and it'll be sent out 30 to 60 days after the hearing, which includes the member's decision and reasons for their decision. Next slide. So let's talk about the landlord's responsibilities, because the landlord has a lot more responsibilities than the tenant. So in the Residential Tenancies Act, remember, that's the legislation that governs the realm of landlords and tenants. Good. Sections 20 to 32 covers the landlord's responsibilities. So let's talk about section 20. Section 20, with respect to maintenance and repairs. This includes maintenance inside the rental unit and outside of the rental unit. So what are maintenance or repairs included that the landlord is responsible for inside a rental unit? This is light bulbs. This is furnace filters. This is, the landlord must make sure that anything that's broken has to be repaired or replaced within a reasonable time. Now, outside of the rental unit, this for example, is grass cutting and snow removal. Now, unless you have a side agreement with respect to grass cutting and snow removal, Section 20 states that the landlord must maintain the rental unit, the interior and exterior of the rental unit. Now, moving on to Section 21, vital services. A landlord cannot interfere or cut off vital services like heat or hydro for any reason. I have many landlords who contact me and say, well, the tenants got paid. I'm going to just contact hydro and tell them to cut off the hydro. Well, you can't do that, because if you do that for whatever reason, the tenant can bring forward an application against the landlord for interference with the vital services. Next. Section 22, interference with the tenant's reasonable enjoyment. So what does that mean? So these are, for example, frequent or unnecessary inspections, excessive emails and text messages, basically trying to harass the tenant in any way, which brings me to Section 23. The landlord is not to harass. So what is harassment? Because now you're going to notice that certain sections of the Act can be intertwined with other sections. So for example, if a landlord is frequently visiting or doing unnecessary inspections of the rental unit, this is not only an interference with the tenant's reasonable enjoyment, but it's also a violation of Section 23, harassment. Next slide.
Okay, so I'm going to give you another option.
So let's talk about 24, okay, changing the locks. If the locks are changed for any reason by the landlord, a copy of the key must be provided to the tenant at the expense of the landlord. Now, failure to do so, failing to change the locks and provide a key to the tenant, this is considered an illegal lockout. And there are very, very strong and heavy cost consequences for an illegal lockout. Section 25, privacy. So remember again, certain sections of the Act are intertwined to one another. So Section 25, privacy, as you can see, an example is frequent and unnecessary inspections, which also falls under Section 23 and 22, which is interference with the reasonable enjoyment and harassment, failing to not harass the tenant. Another violation of Section 25 is installing voice recording cameras without informing the tenants that the premises is on camera and the camera picks up voice recording, or installing cameras facing the entrance of the rental unit. Now, Affixing cameras to monitor common areas is fine, but you can't install a camera that just looks right into the unit of the tenant, because again, not only is it contrary to section 25, it's contrary to section 23 and 22, interference with the enjoyment and harassment. Next.
Okay.
So section 26, entry without notice. The landlord is allowed to enter the property in the event of an emergency. So I'll tell you a story. One day we were doing a property inspection, and there was a lady. She was outside of the property. She was freaking out. She said that she's here to visit the tenant, a specific tenant in the rental unit. And oh, sorry guys, I just got a.
And that you want an order.
Yeah, sorry guys, I just got the message in the chat. Our office is a bit open concept, so you can hear noise in the background. I do apologize for that. We will let them know to keep their voices down. So section 26, entry without notice. As I mentioned, in the case of an emergency, the landlord is allowed to enter the property without any notice. So I'll tell you a little bit of a story. We were doing a property inspection at a smaller apartment building, and one of the tenants there, he had a friend that was visiting who did frequent checks on him. And we noticed that this person was a little bit in distress. So when we tried to enter the building, this person ran up to us and said that, I'm here to visit my friend. When I call him, I hear his phone ring in the rental unit, but he's not answering the door. And we can hear the water is on, the kitchen tap is on. So being informed that the tap has been left on, I mean, if we leave the water running long enough, that can damage, or the sink can overflow and it can cause damages to the rental unit. So as we entered the property, we had, unfortunately at the time, we had noticed that tenant had passed away on the couch. So section 26, entry without notice. Landlords are allowed to enter the property in the case of emergencies, or if the tenant consents to entry at the time of the entry. Section 27, entry with notice. A landlord must provide notice in accordance with section 27 of the Act by providing 24 hours written notice in the event in order to, number one, carry out a repair or replacement or to do work in the rental unit, to allow a potential mortgagee or insurer of the residential complex to view the rental unit, to allow an engineer or architect to inspect the rental unit, or to carry out an inspection of the rental unit if, for example, for the purpose of determining whether or not the rental unit is in a good state of repair and fit for habitation, and it complies with health, safety, housing, and maintenance standards, or for any other reasonable reason for entry specified in the residential tenancy lease agreement. Next slide. Section 28. A landlord must allow entry by canvassers. So, that time of the year you have people running for elections, and they have their team members canvassing areas, knocking on doors to obtain votes. The landlord must allow entry by canvassers per section 28 in order to do that. Section 29, tenant applications. So complaints made by former tenants within 12 months from the date that they have moved out for breach of landlord's obligations, harassment, interference, or by the landlord's agents or employees. This is why I always tell you guys, as realtors, don't get involved with serving legal notices or stay away from, too much interaction with a client's tenant for this reason, is you don't want the tenant to bring an application, not only against your client, but also against yourself. Section 30, order, repair, and compliance. If the board determines a breach of the landlord's obligations, then the landlord and tenant board can order the following. Number one, termination of tenancy. Number two, rent abatement. Number three, authorize a repair within a certain time period. Number 4, order the landlord to pay a fine. And number 5, freeze the rent increase for a certain period of time.
Okay, and this is the part you're not going to like. So I hope
Next.
both of you are sitting down. Okay. As of tomorrow, they're going to.
Section 31, other orders regarding section 29. If landlords, agents, or employees are at fault, the Landlord and Tenant Board can order for financial compensation as a result. Remember, if a landlord is hiring you as an agent, or if the landlord is hiring a contractor as an employee to do some work, if, for example, there are any errors or if a mistake is made, that responsibility lies on the landlord, and the landlord can be held financially responsible.
So this is the way it works. They will
Section 32, eviction with a termination order. The Landlord and Tenant Board can order a termination if a landlord is in breach of their responsibilities, okay? More so, the maintenance and repairs responsibilities, which is the common one. And if the tenant does not move out for the landlord to remedy the issues. So remember, if a landlord has a maintenance and repair that they're trying to carry out, and if the tenant is interfering, then under Section 32 of the Act, the landlord can apply to the Landlord and Tenant Board for an eviction.
That's correct.
Next.
So let me explain why that is, okay?
So now that we've explained 12 sections of the Act about the landlord's responsibilities, let's talk about the 3 or 4 section of the Act about the tenant's responsibilities. So section 33, let's talk about the responsibility for cleanliness, because the tenant is responsible for, this is the key word, ordinary cleanliness of the rental unit, except to the extent that the tenancy agreement requires the landlord to clean it. So what is ordinary cleanliness? So off the bat, a landlord cannot evict the tenant because the tenant is dirty, or there are I don't know, dust bunnies on the baseboards, or dust buildup on the baseboard. If, for example, the tenant is a hoarder, then the landlord can pursue, an eviction or contact the city to send out a bylaw officer. Section 34, repair of damage. The tenant is responsible for the repair of undue damage to the rental unit or the rental complex caused by the willful or negligent conduct of the tenant, another occupant of the rental unit, or a person permitted in the residential complex by the tenant. So if, for example, the tenant takes a hammer and starts smashing the windows, or if the tenant takes a hammer and starts smashing the granite, the tenant is responsible for that type of damage because that is intentional damage. Now, normal wear and tear is not damage. Okay, so if there are holes in the walls because the tenant put up pictures, or if there are scratches in the hardwood, these are normal wear and tear. Or if there's a carpet and over time the carpet has, like the under padding of the carpet has worn down, that's not damage, that's normal wear and tear. Next slide.
That's correct.
So if you remember, changing the locks was also in the landlord's responsibility. It's also included in the tenant's responsibility. Section 35, with respect to changing the locks, a tenant shall not alter the locking system on a door giving entry to a rental unit or residential complex, or cause the locking system to be altered during the occupancy of the rental unit without the express consent of the landlord. If they do, they must provide a key of the locking mechanism to the landlord. Section 36, the tenant shall also not harass the landlord. They should not harass, obstruct, coerce, threaten, or interfere with the landlord. Next. Let's talk about the lease, guys, because I know sometimes landlords and tenants agree to, for example, let's say in the lease you put in the tenant is responsible for grass cutting, or the tenant is responsible for snow removal. Well, you cannot change these responsibilities that I spoke about by either making a verbal or written agreement with the tenant. If you include conditions in a lease that contradict these responsibilities or sections of the Act, those conditions are not valid and not enforceable. There has to be, in order to make any one of these conditions, like if I want Tenants Tina to cut the grass and shovel the snow, I need to have a side agreement, a contractor side agreement in addition to the lease. And in that agreement, I must be compensating the tenant for this duty. No different than contacting a snow removal contractor and having them cut the grass and shovel the snow and paying them a fee to do it.
For them to resolve the matter.
Next slide.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.